And then I'll come back to any of you that aren't unmuted a little bit later before I go into the presentation and unmute you again. So here, tonight we're going to cover planning law. And we're also going to cover how a bill becomes a law, which gives people some fits. Even though it's a small topic, I'll cover it. Here are some of the comments from the spring-summer exam. Know the cases. It makes these questions easy to tackle. Another one had a question about Dillon's Law versus Home Rule, and then Telecommunications Act, which is not going to be covered tonight, but we'll talk about it later. One person said not a lot about law. Another person said they had maybe 2 questions on tribal rights laws history. We're not going to really cover tribal rights tonight. We'll cover another time. Adequately prepared for law, relatively easy, but required some memorization. Another one had it tied to zoning, and they said it was relatively easy, but the zoning overlapped with law questions. Another person said minimize training on history and law because they don't get a lot of questions on it. Now, once we get through this a little bit, I'll go back through and show you how, even though individual people may be only getting 2 or 3 or 4 questions on law, that's maybe over 12, 15 or more cases. Because different people have different cases and things. So this says study the most obvious law cases in a domain, police power, First and Fifth Amendments, pretty basics. Here's another person said, adequately prepared for, mine was heavy on history, law, ethics. So not everybody had the same experience. Another person, and that same person, because it's the same color, red and bold, thought our stuff was better than Planazine that they saw. I think everything was covered. I focused a lot on history and law, but didn't maybe spend enough time on areas of practice. I had a few law cases. I had one early law case, I think Mugler versus Kansas, that I don't think we covered in class. Yes, we do, and we'll cover it tonight. Here's another one that had Euclid case, Hadachek case, Petaluma case, Berman versus Parker, Mugler versus Kansas, something about RLUIPA, Religious Land Use Institutionalized Persons Act. It's a little different than that. Telecommunications Act, Purpose State Standard State Zoning Enabling Act, which we'll cover later. Actually, yeah, and first step after a bill is introduced in the legislature, we'll cover tonight. Another person, again, not a lot on law. I was surprised to see the exam focuses more on the application of everything we learned, history, theory, and law. Adequate prepared for law. Different than we prepared you for. Our lessons focused on knowledge of information like on law, etc., but not on application. And so in the future, maybe focusing on both would help. Learn the fundamentals. This is a lot tougher to do because, for instance, you can take any law case and you might come up with a question of 30 different ways it could apply. So it's a little different. So you have to sort of understand the cases enough on the law cases to know how they would apply to different types of situations and then apply them if they come up in a question. So for instance, the California Coastal Commission case deals a lot with right-of-way along coastal areas. And so if you've got those sorts of premise, they're talking about putting a park at either end and talking about access and along a coast, what would be relevant? If it's something like that, well, you need to think of the California Coastal Commission case. And other ones for other things, like if it's talking about something like a moratorium, you need to think Tahoe, because Tahoe focused on a moratorium issue. So you have to take a first look at that. So it's a little tough to teach you application. We will have practice questions where that comes up a little bit, but you got to get used to being able to do that. Another one says there weren't many law cases, but a lot of times there's principles of the law cases, the principles that the law cases dealt with that show up other ways on the, rather than the law case itself. I probably studied 20 cases in depth, but maybe only 4 law cases. They were easy. Petaluma, Hattachek, Mount Laurel, Euclid. What about tribal lands and type of laws they adopt? Basically, the bottom line on tribal stuff at the level you need to probably know it is if you're a tribal reservation or land held in trust by the government for a tribe, you're basically exempt from all local and state jurisdiction of anything. Planning, zoning, policing, state troopers can't come on reservation land. However, the feds can. For instance, the FBI will tend to involve themselves on cases of murder on a reservation or serious crimes, and federal laws apply to those tribal areas. Now, a tribe can give up that right, like some of the smaller California tribal governments have contracted with a local police department or something to police on the reservation. So therefore they've given up that exclusion to allow the police to come on and use their police powers, although often they're implementing tribal laws, and so they have to learn that. Anyway, that's the basic thing that comes up. I prepared for land use law. I prepared to memorize all the law cases. I had maybe 3 questions, but you saw other people had more. A lot of questions were not cut and paste like I thought. They involved a deeper thought process than just memorizing history of law cases. So it may be application issue. I had Euclid versus Ambler, Berman versus Parker. Henry's class covered everything I need, but I struggled with situation and a couple of the law-based questions. Okay. Kansas versus Mugler, Mugler versus Kansas. This is the right way it is. Livermore, Hattachek, Petaluma, Euclid. Home rule versus Dillon's rule, Petaluma, Hattachek, Mount Laurel. All right. If you go back to just the last 2 or 3 test periods, we're going to count how many these law cases come up over these concepts. So Dillon's rule, home rule, okay, that's 1. And we've got what? Mugler, 2, 3, 4, 5, 6 unique ones. 7, 8, 9, 10, 11. You can see we're getting up there in number of cases. So yes, we may focus on 20 or so cases. Here's another Penn Coal. So 12, 13. So anyway, but we're going to show you what are the main cases you need to know. All right. What I'm doing tonight on law, we'll do it a couple times on our sessions where I think particular outside speakers did real well, and there's not been any real great changes between what they're covering and what's been on the exam recently. We're going to do that for law tonight. We're going to show an old presentation from the spring, and we'll probably do it for historic preservation, and we may do it for transportation once I take a look at what the feedback was in some of those areas. When I do that, I've got to turn off my separate mic and work off the mic on my computer, because otherwise it doesn't work on my computer well to do the GoToWebinar and record it. So if you have a problem, speak up. You should be all unmuted. I will check to make sure you're all unmuted, or put up a question in the question pane and I'll try to look at that. So I'm going to spend a couple seconds here making sure everybody's unmuted. Adela, you're unmuted. Lexi, you're unmuted. Angela, if you'd self-mute yourself, please. Angela, if you'd self-mute yourself. Otherwise, I have to thank you. Arilla, you're unmuted. And I have to do this so you can easily ask questions. Otherwise, I have to mute or unmute all of you, and then only turn you back on it sometimes. Debbie, you're fine. Diane, you're unmuted now, or Diane, you're unmuted now. Aaron, you're unmuted. Hannah, you're unmuted. Katrina, you're unmuted. Kyla, you're unmuted. Laura, you're unmuted. Marguerite, you're unmuted. Self-mute yourself if you would. Okay, and I'm going. Mary, you're unmuted. Mayra, you're unmuted. Natisha, you're unmuted. Richard, you're unmuted. Richard Asafree. And Richard Newburn, you're unmuted, but if you self-mute yourself, please. Tomorrow, you're unmuted. Okay, that looks like everybody. If I don't get feedback, I'll have to come back over here, and if I do get feedback. So we're going to try this now. I've got to unplug my good mic and work off my computer mic. So just hold with me. And start us going here in class. Tonight we're going to cover American planning law. Nancy should be here, hopefully. The traffic may have caught her a little bit. But I'm going to take the time to address some of the past test taker comments. And if you've got a question, unmute yourself and ask me a question. That second video, YouTube here. View and access Senate, which is a term used by the states primarily. Not like in Florida, we use rational nexus, but central nexus and rational nexus, they're often the same thing, although you can consider that rational nexus may be both parts of the test, Nolan and Dolan. But we'll talk about that in a little. Had trouble with Dillon's rule versus home rule. Also, home rule and Dillon's rule came up, but the home rule was different than expected. You had to pick one, and then there's other comments from other years, other tests. Okay, so that's some of the feedback that we had, and I'll put this into a PDF and give it to you along with other things. Now, rather than starting this without Nancy here, I'm going to try to start the legislative steps first, and then we'll come back to this when she gets here. If she gets here, we'll switch right over. Okay, so as you saw from the commentary, there have been questions about what happens. How does a bill? What happens when a bill gets introduced in Congress or in the legislature? I'm going to take the federal process first. You can blow this up on your own. Take a look at more detail. But there's many ways the bill can get proposed or into a congressman, okay, and whether it's a representative or a senator. But anyway, once a bill comes in, it gets introduced as legislation, right, and then it's going to get assigned to a committee. That's basically the first step. Now, in the House and the Senate, there's slightly different things. There's something called a hopper, things like this. Don't get confused by that. I think what they're looking for is probably this first step, which is the bill comes in and it gets assigned to a committee to start working on. Then it starts getting through committee work. It may go through a subcommittee of that committee. It may go through multiple committees. And then eventually it gets up to where it's debated by the whole House or the Senate. And they work on that. And if it gets passed through one of the houses, it goes over to the other house. That's the typical way. Sometimes it can be simultaneously proposed in both houses at the same time. As long as both versions are identical to them, if they get passed by both the House and the Senate, then they can go to the president. And there's different types of veto ways, and pocket vetoes on. don't get hung up on that. Again, I think they're looking for this win. All right. So anyway, this is the whole process. It's pretty straightforward. If it goes through one house and hasn't, like it's gone through the House and hadn't gone through the Senate, then it gets sent over to the Senate. If it gets proved identical to the House, then it goes to the President. If it gets changed, then the House and the Senate have to get together in a conference committee and work out any differences and come up with a consensus bill that goes back to both chambers and gets passed, and then it goes to the President. And just as you've seen in the current one, things can happen. A bill can be passed in the House, go over to the Senate, and the majority leader just decides he's not going to bring it up. And it just sort of dies there then. Okay? Doesn't get a chance to even get voted on. That happens a lot in the type of situation we have right now. So now, that was the federal. I'm going to give you Florida's example of how the legislature works, and it's very similar. All right? It's very similar how it thinks. Somebody approaches a senator, they draft it, they take it, they have a first reading, it gets introduced to the legislature, and then it's going to go to committee hearings. Okay? And the committee can do different things with it. If it gets through all the different committees, including the Rules Committee, then it goes and gets heard by that chamber and gets voted on. If it gets passed on one voter, then it can go over to the other house and do it the same way. And it's very similar. If they disagree or change it, then it has to come back for a conference committee to work it out, work out the differences, and eventually goes to the governor, and which he can do certain things with it. Each state is a little bit different and how their state legislative process works, but this is a general idea of how they do it. Again, I think what they're asking for is mostly this, knowing that the chamber that it's submitted in, it goes to that same process, and as long as it gets approved in the one chamber, it can go over to the other chamber. Once it's approved identically, then it can go to the governor. That's the general process. All right, that's all I'm going to spend the time on it. This is just you can take a look and see how it works, or you can look up a little bit more. They used to have a kids program that always talked about, Capitol Hill, how a bill goes through, things like that. Go look at that if you want. All right. Since we've only got, I don't know, was traffic bad when you came in? Oh, yeah. Parking? 3 hours, 45 minutes. Okay. So we may have a traffic or a parking problem. Oh, you had parking problem? Yeah. Okay. So I'm going to go ahead and start a little bit with Nancy's presentation, and then I'll give it over to her once she shows up here. Because I have not gotten a call from her yet. So, all right, this presentation we originally developed for the 3.0. Well, we developed it here for class, but we turned it into a type of presentation that could be used for the APA 3.0 study guide, which they just phased out. Right? And it's been modified different times as we get feedback. Frank Palin did the original program. Nancy's modified it sometimes. I modified it a little bit to add some new stuff to it. And I've given it, Nancy's given it, Frank's given it. They do a better job. They're both attorneys and AICP planners, but I will take it, my best shot at it. So basically we're going to try to cover 5 sections here. What's the foundation and basic framework for planning law in the U.S.? How do the Constitution and land use regulations come into play? What are the federal power and the nature and limits of those power? We're going to talk about the 5th and 14th Amendments taking, talk about the 5th and 14th Amendments due process, talk about the 14th Amendment, equal protection discrimination, and talk about the 1st and 14th Amendments, speech and religion. For the most part, and I will give you a handout with underlined in it as other related materials here from Frank Palin. You have to know the 1st Amendment, the 5th Amendment, the 10th Amendment, and the 14th. Okay? So the 1st, the 5th, the 10th, and the 14th. Those are the main 4 amendments that they tended to ask you questions on. Then section 3 is going to be about zoning and growth management law. Section 4 will be about standing. And then section 5 is, can you rely on the law? And here is Nancy. I just barely started. Nancy, so we'll take a second. Did Nancy sit? Go ahead and sit here and I'll move the mic over.
Okay.
Okay? Nothing like keeping you ready. They've been having trouble with both traffic and parking, so we figured that was part of what was going on.
Yeah. I had to
So,
park behind you.
yeah, so I went ahead and I did the how a bill becomes law.
Okay, great.
Okay. And I went over the past history comments. Okay.
Okay.
And so I just barely started your presentation because I wasn't sure, but I figured it was a parking
All right.
traffic issue. So we're just finishing the outline. I don't know if there's anything else.
I actually had a updated one, but I think we're okay. I can just add in
Okay.
what we need.
So we just did the outline. So I'll hand it over to you.
Okay.
Make sure that everything. Here you go. See what's going on.
Well, first of all, good for you for taking the class and the test.
We have about 30 online.
Oh, hi everybody. Good for everybody out there.
We'll have some that they come from a little longer way.
Yeah.
So in class they'll show up, but you said you had like an hour and a half. I was hour 45.
Oh my gosh.
I'm near the stadium.
Uh,
But still.
Yeah, no, that's commitment, and I will assure you that this is Henry and Susan give you the best resources and the best preparation, so you can have some good confidence. Things are going to be okay. I'm Nancy Stroud. I'm a land use lawyer, FAICP, and I'm happy to be here. This is probably my 12th time, maybe 20th time doing this. And I rely quite a bit on the original PowerPoint that Frank Palin put together years ago. And okay, that both Henry and I have massaged over the years. So here we go. Let's talk about foundations of land use law and sort of give you a basic framework for thinking about the cases and the study materials that you'll need to be familiar with.
And unfortunately, if you hear a little disturbance, it's food just came.
Okay, a lot of what planning and zoning law is about is the use and regulation of private property. So this slide talks a bit about what private property is. Private property is described in a metaphor called the bundle of sticks, which means that there are lots of different parts to property that together make up the bundle of real property rights. And here we're just talking about real property, land, in other words. And certain aspects of real property include, for example, what we typically think of as real property, that is the surface of the land, where we build our homes and we landscape and we build all sorts of other things. But also, another stick in that bundle includes rights to underneath the surface, the subsurface, and good example of that is mineral or mining rights, and you'll see some cases about what happens when you deal with those rights, like rights in coal mining. And then above the surface, which includes the air rights, and a lot of modern construction deals a lot with air rights because we build a lot taller now than we used to. And then, of course, there's rights to different aspects of land, including water. We have If you're a landowner, you have certain rights. If you're adjacent to water, riparian rights and littoral rights, and rights to underground water. And those rights change according to what state you're in, what time you're in, but that's another aspect. And then there are different rights of use and enjoyment of the property. Of all this basic component of what land and above land and underland is, you have different ways to use the property and enjoy them. So you have the right to use and enjoyment. You have certain rights to what the law calls alienate land, which is, sell, lease, devise, meaning pass down to your heirs. You have rights to exclude others in American jurisprudence, and that's a very important right when it gets to constitutional takings claims. And you have a right to derive profits and produce from the land. That doesn't mean these rights are unlimited, and really what private property law is about is how limited, how restricted or unrestricted those various aspects of rights are. This slide shows a map of main legal systems, which sort of gives you a basic background. The legal systems in use in the United States are civil and common law legal systems. Civil law being what is enacted in statutes and legislation, and common law being that kind of law that's been passed down to us through case law. You can go to the next slide. All right, so it's important, and this is a good test question, to realize that our American system of private land use regulation really is based basically on nuisance law. That's the original law that forms the basis of American land use jurisprudence. So nuisance in American law is a common law principle. It's an old English, common law principle handed down through case law. Now also can be governed by statutory law, and it's what's called a tort, which is a great legal term for what is a civil injury. So anybody who likes Scrabble, tort is a really nice word that unless you study law, you might not really realize what it means. So the general rule of nuisance is that old adage that my home is my castle. I have a right to quiet enjoyment of it. In other words, you have a right against nuisances to your property. There are two different kinds of nuisances. One is private nuisance, and that's what's normally thought of as, the tort of nuisance. It probably covers 90% of all nuisance actions. And that a private nuisance is when your neighbor's conduct interferes with the quiet enjoyment of your land. In other words, your neighbor's impacts extend past his property boundary onto your property in the form, in any kind of form that are have adverse impacts, such as pollution, smells, sounds, vibration, other kinds of indecent conduct. Your remedy in tort law for a private nuisance is money damages. You have the ability to say you have reduced the value of the enjoyment of my land, and you have to pay me for that value. The other kind of nuisance is a public nuisance, and this is where a person's unreasonable conduct interferes with the public's right to health, safety, peace, and so forth. And the remedy in that instance is the person who's generating the nuisance has to stop, because the public interest can't be remedied by simply paying the public. You have to stop the nuisance. So where does this come in? Well, in one of the earliest cases in zoning law, Hadachek v. Sebastian, which is more than 100 years old now. We started teaching this when it was less than 100 years old. Now it's 100 years old. And that was an early zoning case out of Los Angeles, which had established zoning districts, including one big residential zone. And those new zoning districts covered basically a non-conforming industrial use, a brickyard, and basically said you can't have a brickyard here, because having a brickyard is not what we want in this residential area. And the brickyard owner sued and said, well, this is irrational, unreasonable, and if we can't have a brickyard here, then you have to pay us for the devaluation of our property here. And in this case, it eventually got to the Supreme Court and said, no, a brickyard in this instance is a nuisance, a public nuisance. And there's no compensation due you for the abatement of a public nuisance. You cannot maintain your brickyard. So this is sometimes surprising to people to think that long ago, the Supreme Court might have said pre-existing industrial uses, too bad, if you're zoned in a district that doesn't allow that, we're not going to require the city to pay you for that. And that is the prime example of zoning's history from the law of nuisance. Okay, so yes, sir.
Next question about that case was, before they divided into 27 pieces, did they change the zoning of that one district? Meaning when
They added the land.
Yeah, that's right. They had annexed it in. It had not had zoning before. They annexed it in, and then it was subject to the zoning.
Annexed it into the city, and then created the zoning district, and it was basically non-conforming.
And remember, at this period of time, there were very few places that had zoning. So it wouldn't be surprising that newly annexed areas just wouldn't even have zoning. Okay, so the other kind of regulation that is very important in terms of foundations for land use regulation is in easements, covenants, and licenses in contract law. And private contracts obviously govern land which is subject to those contracts. It's sort of the twin to the public government regulation of lands. But private contracts and easements and regulations have a problem in that they usually are limited to certain impacts or to a certain area. They're expensive to enforce. You normally have to enforce them through the court system instead of through a government regulation system. And that kind of enforcement is very slow. It can be very expensive and thus is ineffective. So that traditional way of regulating land use through private covenants over the years has been found to be really insufficient to deal with a lot of the public issues that are dealt with through zoning. So the solution to that limited ability to regulate land use has been to have government regulate to protect against private nuisances, a neighbor's selfish exercise of their property rights, and planning and zoning are thus born. Okay, so government has a wide variety of ways to plan, to influence the development of communities, all under the public purpose to protect the public health, safety, and welfare. And this is a list. I mean, it's obvious government can create wealth by minting money. Government taxes and spends, that reallocates resources. Government has eminent domain or condemnation power. It can take property. Government has contract powers, and those powers are used to purchase land, to borrow money, to employ planners, to establish regulatory systems, etc. Government owns and operates infrastructure and land. Government regulation creates private property, or at least the definitions and boundaries of private property. Regulates interactions with other governments, issues development orders and permits, and has enforcement power. So there's a wide variety of government powers, and zoning, we're really talking about one slice of that extensive system of power. So, and that slice is really the use of zoning through the exercise of government's police power. What is police power? It's not law enforcement and sheriffs and police departments, although that's part of it. Police power is a very general, that's what the courts term, the very general ability of governments to protect the public health, safety, and welfare. And in that regard, the police power, when it is exercised through legislative action, through enactment of laws or regulations in the court system, are presumed to be valid and constitutional. Any private party or any party challenging the exercise of legislative police power has the burden to prove that the exercise of that police power is unreasonable, unless the Supreme Court or the statutes shift that burden. But generally, 99% of the time, the burden is on the challenger. And another old case, the Munn versus Illinois case from not last century, but the century before, was an early example of the Supreme Court allowing states to use their police power very broadly. And in this case, Illinois had passed legislation to regulate railroad hauling rates, and the railroads sued and said that's beyond their police power. And the Supreme Court said no, that the police power is a broad power, and in that instance was not unreasonable. A very early example. And there's more detail.
Okay. You ask about this case sometimes on the exam.
Yeah, you can read that. I don't need to read it, but that is somewhat likely to appear on your test. So this is a good one to know. Next slide. Okay, so governments have different kinds of police power, depending on what government you're talking about. The police power is exercised differently. So, for example, starting with the federal government, under the 10th Amendment to the Constitution, the federal government is limited to powers that are specifically enumerated in the Constitution. So that's a limited power. All other powers are reserved to the states because we're a republic and the states maintain their own kinds of powers. So limited federal government power, how has that played out? Actually, federal regulatory power has nevertheless been broadly implied. So the courts will basically say if it involves commerce, because of the Commerce Clause in the Constitution, we're going to say that it's within the federal powers. But mostly the police power is vested in state governments, and it's considered inherent in the state sovereignty. And in that sense, it does not need to be expressly stated in state constitutions. And in fact, states have power over local government so that state may preempt local government. They have the ultimate legislative power. And we see that in Florida and other states recently. There's been a big push really nationwide to limit powers of local government for certain kinds of actions that, frankly, lobbyists have figured out. They can get the state to say what the regulation of a certain thing can be. Today in the Florida legislature, for example, it's the banning of sunscreen that the state the legislature is now considering that they need to have a statewide regulation so that local governments cannot ban sunscreen. Let's talk about local government power. This is an issue that can come up on your test. The powers of local governments depends on what kind of state you're in. And there are two basic kinds of states. One is where Dillon's rule applies. Dillon's rule is actually out of Virginia, but it describes a situation where the state holds on very tightly to its powers, and unless it expressly delegates to local governments a certain regulation, then local governments are considered not to have that. Florida used to be that way years ago, and so you can sometimes see old local legislation, the original zoning acts in many local jurisdictions in Florida originated out of some special state legislation for them. But since the 60s, Florida's been considered a home rule state, and that's the opposite of Dillon, meaning that if a municipal government is presumed to have power, police power, unless it's expressly or impliedly restricted by the state, preempted to the state. Okay, and then another kind of local government that is important to think about. We think of cities and counties as, local governments, and they are because they're general purpose local governments, and they're the predominant ones in terms of having broad powers. But there are lots of special districts and public authorities within the state. If you're not a city or a county, you're generally a special district, and those do not have home rule powers. Those special districts are like the old municipalities that they only have the certain powers that they're granted by the state. The last place where the police power resides is in the people, the population, through the power of initiative and referendum. If the state constitution has given the population that power, and that is the power to enact by the ballot through a process that's either an initiative or referendum process, general legislation, or to veto legislation that local government or the state might have enacted. So that's kind of the breakdown of the places where the police power is found. Okay, in speaking about police power, it become obvious that in our system of government, we have a federalist system, meaning that we share power between national and state governments, as I described. That's not true in all places in the world, obviously, but it is true in the United States. The next one.
For example, the United Kingdom, if you want a land use change, you basically have to get Britain to approve it in most cases, right? So everything goes to the top. The top, that's what the unitary system sort of is. And before we go on to this next section, let's stop just for a second. I've unmuted many of you. I'm not unmuted all of you that joined late. If you have an issue and I don't see your hand go up, call Susan Kokenauer at 561-523-0677 and let her know what your question is, and she'll try to bring it forward. Okay? Or you can email her at Susan Kokenauer, COUGHANOUR at AOL.com as a text message, and she'll get it that way. Okay? So we've had problems before. We had the audio go out a couple times ago.
Oh dear.
We didn't realize it here.
You can text or
So you can text or email.
text us to the cell.
Whichever. Okay. All right. So going on.
All right, so we're going into another section where we talk about the U.S. Constitution and land use regulation. This is a very rich section for test questions. So we're going to go through the U.S. Constitution and specifically various amendments in the Constitution that come up in land use regulation. So if you see on this slide that we're going to be talking about takings.
There was a request that you could explain the special/general rule again. She didn't quite understand.
The what rule?
Special
Special-
purpose.
/general rule. I think she
The general purpose
Okay.
is a special purpose.
All right, so
At the bottom, there's general purpose and then special purpose.
Yeah. There are various kinds of local governments. We think of local governments sometimes as being restricted to cities and counties. Those are considered general purpose local governments. They have very broad powers to do a lot of things. And in home rule states, particularly, they have all powers except, of course, if they're preempted by the state. That is contrasted to special purpose local governments, which are limited governments. An example of that might be a community redevelopment agency, a water district, any district that is formed for special purposes, a beach renourishment district.
A lighting district, a fire district.
Yeah, a fighting district. There are hundreds of special districts. Those special districts do not have general powers. They do not have home rule powers. They are specifically limited in their authority to what the legislature has created for them in the statutes or in local special.
Now, there is a
legislation.
slight difference between Florida and some other states. In Florida, these are basically overwhelmingly created by legislative action, which limit their powers. In some states, special districts can be done by referendum at the local level, all right, but it still limits their power. It's just a slightly different way they're done in different states.
Okay. So,
You have to speak up real loud,
I
Susan.
know, you might want to talk about community development districts in Florida that are creating new development.
Well, she mentioned about CRAs.
But they're not all CRAs.
no, I mean, there are lots of different, and what Susan is saying is, especially in Florida, the use of community development districts is very prevalent, because community development districts can be created, limited purpose districts, to build infrastructure in new developments, basically. So, whereas CRAs are usually downtown, already established buildings that are being redeveloped. So let's go back to the U.S. Constitution and the various amendments that come into play in the cases we're going to talk about. All right, so the Fifth Amendment to the Federal Constitution has a number of protections for people. One protection is against takings of property without just compensation. Another protection is the equal protection of the law. In other words, it's an anti-discrimination amendment. And a third protection in the Fifth Amendment is the protection for procedural due process and substantive due process. All those protections are made applicable to the states, so the states also have to enforce these protections through the 14th Amendment. Okay, so the Fifth and the 14th Amendment are joined when we talk about protection against takings or equal protection or due process. There's another important constitutional protection in the First Amendment to the Constitution, which protects free speech, protects freedom of religion, and protects against the establishment of religion. Again, that First Amendment to the Constitution, which is original to the Constitution when the Bill of Rights was adopted, was made applicable after the Civil War by the 14th Amendment. So the states have to protect those First Amendment freedoms as well through the 14th Amendment. So this slide goes over what we just said. The First Amendment protects religion, speech, and the ability to petition the government for redress. The Fifth Amendment, quoted here, contains provisions so that persons cannot be deprived of life, liberty, or property without due process of law, and private property cannot be taken for public use without just compensation. And I had mentioned the 10th Amendment earlier in the preemption slide.
The 10th Amendment, the original 10th Amendment, when the Constitution was first passed, basically laid out what powers the states, basically said all powers not reserved otherwise are granted to the states. The Constitution limits what the federal government can do. After the Civil War, the 14th Amendment basically applied, it said all those first 10 amendments also apply to the states, and therefore the creations of them, which are local governments.
So this slide explains what Henry was just saying, that after the Civil War, originally to protect newly emancipated enslaved persons, made applicable all of those first 10 amendments to the states. And so you see the quote here from the 14th Amendment that says, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction equal protection of the laws." So that covers those items that the earlier slide covered. And you see after the Civil War, this slide shows other amendments that were enacted after the Civil War, again, to protect newly emancipated persons. So a very predominant issue in land use regulation is takings. So next couple slides are about takings law. And the first question is, what is a taking? And that's a question that's been answered over the years in various different ways, because the courts have decided that there are different kinds of takings, and depending on what taking we're talking about, there may be different protections around it. So the easy example of a taking is government's physical invasion or condemnation of private property. And that's basically what originally the Fifth Amendment was thinking about, where government comes in, says, okay, this property is no longer yours, it's the government's, you know, you've got to leave or we're going to otherwise restrict you. And the Magna Carta, back in, you know, old England, had protected people, freeholders, from that sovereign power by requiring the king to pay those who were displaced by that action. And so that's carried over into the Fifth Amendment, and that's the sort of old idea of what a taking is. It's eminent domain. And the courts identify this now as what they call a per se or categorical taking. And that's specifically relevant to land use law, because this kind of per se or categorical taking really only happens when you're talking about regulatory takings, and what they mean and how we're protected. So in a regulatory taking case, the state is not coming in to physically expropriate the property, but they're regulating the property in a way that interferes or limits the private property owner's rights. And that action, that regulatory taking, is also known as inverse condemnation. It's not the regular, you know, physical condemnation. It's inverse condemnation through government action. And then there's another kind of taking. At one point, the court considered exactions or conditions on permits to be another kind of taking. Conditions that require contributions of property or money, for example. So we can go through a number of cases related to all of these kinds of takings. Okay. So very, very important case. You need to know this case, Pennsylvania Coal versus Mann in 1922, has the classic statement on the limits of government in regulatory takings. And this was a case where the coal company had sold surface rights to a person to build a residence on land, but had reserved the underground, the subsurface rights that we talked about earlier, to mine coal in a private contract. That was very common, you know, back during the big coal mining era. And that contract went back to 1878. But around the 20s, when it became obvious what mining coal does sometimes to the surface, like causing, you know, land to subside, this state in Pennsylvania enacted a statute that prohibited mining of coal if it caused subsidence of a residence. And so based on that statute, man, who was a property owner of the surface rights, sued to cancel the covenant made by, covenant by contract with the coal company that owned the subsurface rights. And it made its way up to the Supreme Court. And coal company said, this is not, the statute is unconstitutional. This is an example of a regulation that takes our property, takes our subsurface rights, and it should be proclaimed unconstitutional. And the Supreme Court agreed with that. They said that the property rights were taken by the state by that statute, and described a rule that if regulation goes too far, it will be recognized as a taking for which compensation must be paid. So the Supreme Court said here, we're not going to say the statute's invalid, but if man wants to cancel the contract, then damages are due to the coal company. Okay, so the question then becomes, when does a regulation go too far? And a lot of the subsequent cases are about that. Fast forward to 1978 and another Pennsylvania case, don't get it confused. Pennsylvania Coal is Pennsylvania Central Transportation Company versus the City of New York. This case is about the New York City Landmarks Preservation Law that was adopted and applied to protect Grand Central Station. This Landmarks Preservation Act, which you probably learn in other parts of your studies and maybe tested on, was a reaction to the demolition of another great station, Penn Station, and the city decided that it would apply historic preservation and enact this Landmarks Preservation Law. And the law protected the existing Grand Central Station from development that would be contrary to historic preservation aspects. It did establish a transfer of development system at the same TDR system, transfer of development rights system at the same time, so that owners whose properties are landmarked could transfer their air rights, above the surface, above the building that they already had, to other sites in the area. And there's more specificity in the landmark law that says just how that would work. But the transportation company was not happy with this landmark preservation law, and they sued and said that this was a regulation that went too far, and it should be considered inverse condemnation and regulatory taking. So this was the opportunity for the Supreme Court to say what it means for a regulation to go too far such that compensation is due. And the Supreme Court put together a three-part test that is still applied today to determine in case-specific, fact-specific circumstances whether a regulation is a taking. And the court said you really need to look at, one, the entire property, not just a portion of the property. It's the whole parcel rule. In other words, that property is a bundle of sticks, and just because you take out one stick doesn't necessarily mean that you've gone too far, because you have other sticks in the bundle. So the court's always going to look at the whole entire property, not just the air rights, for example. In this case, they're not going to say, okay, you took away all the air rights, so that's a take-in, you have to pay for the air rights. They're going to look at all the other rights that the owner has. including the right to transfer development rights. And the three-part test, once you get past the entire property, is the court will look at the owner's reasonable investment-backed expectation of value. What was the owner's investment expectations at the time it purchased the property? It will also look at the nature of the governmental action to see whether it's a per se taking, is it a physical invasion, or is it what the court called a mere regulation of use, and the reasonableness of that use. And then the third test is to what extent the regulation has diminished the value of the property. Three-part test, very important to remember. This is pretty much really basic and may very well come up on your test. The next slide. So in this particular case, the court determined that this was not a regulation that went too far, that the transportation company still had the present use of the terminal, can use the property precisely as it's been used for the past 65 years, and that the court determined, since the transportation company had owned this for many, many years and been using it for this purpose for many years, that was the reasonable investment-backed expectation of the company. And also decided that based on the record, there was a reasonable return that could be expected on the investment. So, in summary, owners could not establish a taking merely because they were denied the right to use their airspace. The landmark law was considered to be a reasonable law, comprehensive plan for historic or aesthetic purpose and not discriminatory. The fact that the law affected some owners of landmark properties, more than others, did not itself result in a taking. Again, that there was no interference with the present use or reasonable rate of return on the investment. And the TDR system, in this case, what entered into that calculus when the court said we have to consider that air rights could be transferable to other parcels, so that this was part of the way in which there was a reasonable rate of return. Yeah.
I think I missed something big, so I could just try to speak that question. A landmark is a type of taking, is that correct? Potentially, or potential criteria for taking. And I guess I'm asking you more holistically, is it taking considered okay according to the Constitution that meets that high threshold you alluded to? And I'm sorry if I'm not using the right nomenclature, but I'm asking, like, what is the source of that allows for taking to occur?
Right.
Is it the Constitution, or is it by delegating the states? I'm sorry, I lost where it came from.
Okay.
I'm sure it's really important.
Okay, let me answer that in a couple of ways.
Okay.
We're talking about, at this moment, the U.S. constitutional protections against takings. States also have their own takings constitutional protections.
Okay.
And often the courts approach those the same way they approach the federal takings law. But right now we're just talking about federal takings law as applied to the states through the 14th Amendment. Okay. And what this says, what we're talking about is when is there a taking? Because if there is a taking, just compensation is due under the Constitution. If there is a taking, just compensation is due. Under the Constitution.
Is it under amendment?
Yes, it's under the 5th Amendment and 14th Amendment. Remember, 5th and 14th. Okay, so in this case, in the Penn Central case, the court decided this was not a taking, so no compensation was due. Okay, and they used the three-part test that is in the prior slide to analyze when there's a taking and when there isn't, and applied it to this case. And so that's what the courts will do. They will look at the particular facts of the case and apply that three-part three-part test to a regulatory taking. One caveat: if it's a per se taking, if there's a physical invasion, not an inverse condemnation, but a condemnation or physical invasion, the compensation is due.
And that Penn Central case was the Preservation Society the Preservation Commission a state commission?
Yeah, no, the landmark law was adopted by New York City. Yes.
And the 14 can apply to states and cities.
Yes.
Well, okay.
Yes. For the purposes of the 14th Amendment, local governments are like the state, because local governments are creatures of the state. Yeah. Yeah, it's all covered. Great. Okay, basic questions. I know it, otherwise it's a lot of new stuff to think about. And so here's an example. This case, Loretto versus Teleprompter, CATV, involved a cable company. And this is an example of where court considers a physical taking to be a per se taking and compensation is due. In this instance, New York state law required landlords to enable cable TV wiring on buildings without payment to the building owners. And the landlord said, wait a minute, why should we make our buildings available to cable TV folks? This is a taking of our property, and we're due compensation. And the court said, when it eventually got up to the Supreme Court, yes, we believe this is a physical invasion. You physically have to have the cable on your building. It's not just a regulation about how you use the building. It's you have to give up your property, no matter how small, to put the cable on it. And that we consider a per se taking, and that's due compensation. So they send it back to the lower courts to determine how much compensation the landlords were entitled to. And in the end, the courts decided, well, very minimal, because in fact, once the cable equipment was there, it actually increased the property values. The landlords won, conceptually, but the damages were $1. Okay. Another twist on the takings law is the issue of temporary takings, when a government regulation regulates, but only temporarily, only for a certain time frame. And the case that embodies this principle is a case out of Los Angeles County, First English Evangelical Lutheran Church versus Los Angeles County. The facts in this case involved a church that owned and operated a camp for disabled kids, basically in a valley outside of Los Angeles, in Los Angeles County. And that church camp was destroyed by a flood. And as a result, the county decided it needed to figure out better flood regulations, and it adopted a moratorium prohibiting reconstruction of that camp and buildings within floodplains for a certain time frame while the county figured out better flood regulations. And the church said, well, we're unable to use our property. The county should compensate us for our loss during that time period, the moratorium time period, where we can't we can't use our property. The state courts in this case said that if there was a taking here, you could, that the regulation had to be invalidated, but they wouldn't provide a remedy of monetary damages. So it went up to the Supreme Court. The Supreme Court said where there is a temporary taking, just like other takings, monetary damages can be due. It isn't, unlike what the state was saying, it's not just invalidation of the ordinance. In fact, it's a monetary remedy. The court here did not actually decide if it was a taking. It was just a question, conceptual question of what the remedy would be if there was a taking. So it sent it back to the state courts to decide whether there actually was a taking, a regulatory taking. And in that case, on remand, the state courts decided that no, using that three-part test, there was not a regulatory taking here. That, one of the tests is, how reasonable is the regulation? And the court said, obviously, there's a public benefit in keeping handicapped children out of harm's way. Well, there's a better regulation created, and that outweighed the church's economic loss.
Yes. Speaking of, as natural history, more on topic of moratorias, how does the APA normally, as a very legal?
Well, there's going to be a case that's going to come out.
Moratorium.
Yeah, we're gonna talk more about moratoria later on, but this is a good moratorium case in terms of showing you that moratorium are not necessarily takings, and they're not. But if they are, that monetary damages can be a remedy.
I followed the legal steps that you went through. I'm an engineer, but I don't want to get off topic, but I just don't understand why this was interim moratorium. Did they do some remediation there? Like, it doesn't make
practical sense. Oh, well, it makes a lot of sense because the reason for the moratorium not allowing rebuilding in the floodplain while the state created flood regulations was to give the state time, like all moratoriums, to actually do the regulations and apply them. Right, and the state said, we're not going to allow the church to rebuild while we're doing those regulations. By the time we get our regulations done, it'll be too late if we determine that the regulations say they shouldn't rebuild there. So we're going to stop the rebuilding until we've adopted our regulations. Did I say state? I meant it's Los Angeles County.
It could have gone any direction. It could have gone, you have to wait for the regulations. You can't do anything until the regulations are issued.
Correct.
And then
in this
big
instance.
question mark what that regulation.
Right.
Yes. Yeah. And we'll talk about moratorium and when they're considered reasonable in later cases.
One of the issues with floodplain regulations is that there's some technical evaluations that need to be done. And usually there are, I'm standing right in front of the microphone. And part of it is you want to avoid any kind of development in certain pieces of the floodplain, like the flowway. There are also issues of compensating storage in other parts of the floodplain that have to be taken into account. There's issues on minimum elevations, things like that. So that's the whole point of having a moratorium while you're developing those regulations.
I'm just, because of my age, I'm just more used to like the floodplains being already delineated before this.
That was 1987.
Spoken like a true ex-employee of the Water Management District. Okay, let's go to the next slide. All right, another case that comes up that's important is, and it's very applicable in Florida for those of us here in Florida and those listening, is the Lucas case, Lucas versus South Carolina Coastal Council. And this was a case where South Carolina experienced a hurricane, the state denied building permits on 2 oceanfront lots that had been, vulnerable to the hurricane. The state had established a coastal regulation that created a setback line. We're familiar with that in Florida. So the buildings were supposed to be constructed landward of the setback line, but in this case, the lots were seaward of the setback line, so the regulation would not allow buildings in that area. And the owner, Mr. Lucas, challenged that regulation as denial of his building permits and said, this is a regulatory taking. If the state wants to say I can't build there, then the state should purchase this property, pay me compensation for the property. And in fact, the Supreme Court agreed, calling this a per se categorical taking. In other words, a regulation that denied all use of the property, all economic use of the property, like a physical taking, should be compensable. And in this case, because there was no use of the property left, the court said there wasn't even any need to examine the underlying public purpose or justification of the regulation. The state went too far, pursuant to that very early case we talked about, the Pennsylvania coal case. So this is probably the main reason that you see coastal regulations allowing construction within areas that you think probably should not be constructed upon, because if you can't construct anything, then you're considered to have suffered a per se taking. So the story here is that when this case went back down to the lower courts, the parties settled, and the state actually ended up buying the lots, and then the states sold the lots. And I don't know, I'm sure we can find out, and I should for the next time, whether or not there's actually anything built on those lots now.
I think there's, they were an area where there were a line of other units that were there. They moved the setback line, and those lots were the vacant ones.
Gave them an exception and allowed them to build. Okay.
Here's our other moratorium case.
So having gone through that per se taking analysis where you can't do anything on your property, the next question presented to the court was, okay, suppose you have a moratorium. Now, would you say, because you can't do anything on your property during that moratorium period, that a temporary moratorium is a per se taking? Can we expand the Lucas decision to undo what was done in the Los Angeles County case? And this is the interesting thing about takings cases. There are always a lot of different permutations in a different court and different fact circumstances. And whereas plaintiffs here thought they had a pretty good case based on Lucas, turns out they didn't. And this Tahoe case involves a regional planning agency, a multi-state regional planning agency formed to protect Lake Tahoe, which anyone who's ever been to knows that it's an outstanding, incredibly beautiful and pure lake, and for that reason has been a place where people want to build a lot of residences. And it became pretty obvious that lots of building there was going to adversely impact the the lake unless there was some good regulation. So the planning agency enacted a moratorium, in fact, enacted one and then extended the moratorium so that building permits could not be issued during the moratorium while they created their new rules. And it ended up that the moratorium took about 32 months during which owners could not pull the building permits.
So they had it on and off and on.
Right, but the court was presented with this 32 months. Is that, unreasonable? And the court said, well, in every taking case, we have to look at all the facts, and it's very case specific. So they looked at these facts and they applied the criteria of Penn Station, Pennsylvania Coal. I don't think that's right. It's the Penn Station case where you look at the parcel as the whole, look at all the rights available to the landowner and apply the 3 criteria. They said, in this case, if you look at the parcel of the whole, the time period is part of that whole system, that whole bundle of rights. So you might not be able to build during this limited moratorium time period, but you have rights to build after that. So we're going to look at your rights more generally as a whole. And in this case, we're not going to consider a moratorium a per se taking. And then, the case also has language about how beautiful the area is and how important the regulation, the public purposes for the regulation is. So, on to the next slide. One of the questions that's come up.
I had a quick question about the last one, just real quick. Can you hear me?
Go ahead. Yes.
So was there any compensation, or was that not required for that moratorium?
Because there was not a taking, there was no compensation due.
Okay.
Compensation is only due when the court finds a taking. And then they determine how much compensation is due.
Okay.
If there's no taking, then there's no compensation. Okay. Then another issue that's come up in takings cases is related to that one test of the 3-part test about the owner's reasonable investment-backed expectations. And the question here is, if you buy property and you know that property is restricted and severely restricted, can you then later claim that the state has taken your property? And this case came out of Rhode Island and involved a wetlands area where the state regulated wetlands, but went through a rule change to make wetlands restrictions, more restrictive. When Mr. Palazzo acquired the property, the wetlands, it was after the rule changed. He was denied a permit under the old rule and sued for inverse condemnation, saying that, well, I knew that you were changing your rules, but you denied me this permit and it's unreasonable, it's a taking, you should pay me compensation. The state courts threw him out and said, you have no standing to sue because you acquired after the rule change, so you can't claim, you don't have a claim now. But the Supreme Court took up the case anyway and said, well, yes, even though you knew about the change of a regulation when you bought your property, that does not automatically mean that you can't bring a takings claim. that there's, the way they said it, said there's no statute of limitations on the exercise of constitutional rights. If the regulation is unreasonable and, you know, denies a reasonable use of the land, then it shouldn't matter that the property owner took after the regulation was adopted or before. If it's unreasonable otherwise, then it's unreasonable for anybody. Prior knowledge does not preclude a taking. Again, on remand, the owner had won at the Supreme Court conceptually, you know, on this principle, but when it got to the details of the case, the court decided that there had been no unreasonable loss of value as a result of the wetlands regulation. All right. Did you have a question? Okay. All right. Let's take another a look at takings law and police power aesthetic purposes. One of the tests of takings, again, relates to the reasonableness of the government regulation. And there have been challenges to regulations that were considered to have a purpose only for aesthetics and nothing more. And one of the first cases that challenged actually a condemnation, an urban renewal law, where the Washington, D.C. urban renewal law allowed for condemnation of property based on blight. The court decided that an aesthetic and a redevelopment purpose was a legitimate purpose for the use of the state's condemnation power. So this was a great confirmation of the use of police power for aesthetic purposes. Fast forward, this was a 1954 case, and fast forward to 2005, where the city of New London, Connecticut, had a urban renewal program where they justified condemnation of an entire neighborhood solely on economic development purposes, where there was no blight or slum conditions that had been proven. The Supreme Court was asked to determine whether that was a taking, a regulatory taking. In other words, did an economic development purpose in itself without blight or slum conditions justify the regulation? And the court decided that there was sufficient public purpose under the Fifth Amendment to consider that this was not a taking. And they hearkened back to the Berman v. Parker case, and in this case deferred to the legislative judgment. So this may be a surprise to some people that the Supreme Court said that was fine, because the reaction to that in the states was to politically go back. Many legislatures went back and looked at their community redevelopment legislation and made sure that economic development in and of itself was not sufficient from a statutory standpoint. So a lot of those statutes got changed.
So I'm just asking, at the end in New London, everybody just lost their homes and they had to leave? Like, what was the actual?
What happened was that their homes were condemned. They were paid just compensation, but yes. But-
Even though it wasn't defined as a taking.
It was like, it was.
It was a legitimate taking,
I'm sorry.
and they were given just compensation.
Why does it say they're not a taking under SCOTUS paragraph? That's why I said that. That's why I'm getting confused. Why-
Because there was a legitimate public purpose. So the condemnation,
I'm reading not a taking.
you're right. What, just go back to the principle that economic development and aesthetic purposes are sufficient public purposes to justify condemnation, that the government can take for those public purposes. But if they take, then they have to give just compensation. That is a confusing slide. We will change that.
It was a taking.
Yes, it was a condemnation. It was the old-fashioned condemnation, and it was
Nancy-
justified as a legitimate exercise of the police power.
Nancy, I had a question. Isn't it true that Pfizer never came to the city of New London after this?
You're the first person that ever pointed that out, so we will correct that.
It is a taking. It's not a taking.
What slide is that? And we have
There's just an error.
a number.
I can't tell without.
All right, it's the Berman slide. Good.
Yeah, I mean, realize that every state in the union has some restrictions on community redevelopment. And what it did here in Florida was that Riviera Beach was about ready to go with their big redevelopment, do a lot of eminent domain. And what the state legislature did in Florida was they said, you cannot use eminent domain for community redevelopment type agency activities. To take property, you have to do it from willing sellers.
In all actuality, the state completely stripped community redevelopment agencies for all powers of eminent domain. And they also, so
Yeah.
all CRAs in the state were stripped,
So, and that's what happened to Riviera Beach.
all
Now,
CRAs.
around the country, it happened in different degrees. But there was basically all 50 states have passed some reaction to Kilo. It's a gradient of what they did. Florida's on one end, a little bit more, which basically said, you can't use eminent domain for this type of activity anymore. Okay, go ahead.
But isn't that against the federal law?
No,
No. The takings law that we're talking about is whether the Constitution protects against takings. The government, the states can further restrict police powers. So,
Okay, got it. So the
So-
federal like, it gives like sort of the option of doing the taking. If there is a taking, you're to just compensation. I'm sorry.
but Florida outlawed the ability to take people's homes, for instance, or to take private property for redevelopment purposes. Nancy can say it better than I can, but
But I'm saying, I'm sorry if I'm just narrowing it too much, but it almost seems like functionally that, like the federal law gives the states the option of doing the taking. But if they don't, I'm sorry, if they do, if it's in their statutes that they can do a taking, then they must compensate it.
no, let me put it one way. The state law can be more protective than the Constitution. The Supreme Court can decide as a constitutional matter that this isn't an issue. But the state can say, but we want to further restrict, regulation, and we're going to do it by statute. And that's exactly what they did for the community redevelopment statute in the states. So even though it's not a constitutional problem, it could be a violation of the state statute because the state statute is more restrictive.
now, if they needed it for a road, if the same city wanted it to put in a road or a new public building, that may be okay. Because it's not restricted, but in Florida, you can't do it for redevelopment purposes for the reasons that I don't like that.
I'm sorry, I'm just going to slow from the outside, but the federal laws that rules that allow for taking in the first place? Are they are they geared towards is the client, if you will, the state, or is it the citizen? Or
It's a person's rights under the Constitution.
to be compensated
Yes.
for the state taking from it? If the state
If it's a federal constitutional violation, then if the state has regulated in violation of the Constitution, then the federal courts will say you have to compensate.
Maybe
Right.
part-
Then now the state statutes are sort of a different level of regulation. So you might be allowed to do something that's constitutional, but the state can say we want to be even more restrictive. So, and the Constitution, it's not a violation to have a condemnation for economic development purposes. But under the statute, it's a statutory violation because the legislature has decided, as a matter of state statutory law, that's a violation.
Realize that Kilo was saying, even if you say that you can take my house and you're going to compensate for me, that's illegal because there's no slum and blight present, okay? And the court said, no, they can do it. For economic, for reasons or not.
Under the Constitution, they can do it.
Under the Constitution, but the state can further restrict it.
and I apologize, which amendments did the case law originally have?
The 5th and the 14th are the takings.
And I'll give you
Amendments.
copies of the Constitution with the 1st, the 5th, the 10th, and the 14th underlined. The appropriate sections that come up in fact. We have a little over. Just about an hour.
Okay, that's quick. Keep going. Another area that's been of particular interest on the AICP exam is the area of exactions. And there are several important cases in exactions law. The first being Nolan versus California Coastal Commission. Now, exactions are when a permit is conditioned on the permit holder giving something to the agency that permits, dedication of land, fees. In this case, it was public access to the general public. This case comes out of California that regulates coastal construction through the California Coastal Commission. And one of the policies of the California Coastal Commission is to help ensure public access to California coasts. In this case, the Nolan family had an oceanfront bungalow that they wanted to tear down and erect a larger house. State agency said, fine, we'll issue you a permit, but as a condition to the permit, you have to give back to us an easement for public access along the beach, what's called lateral public access, Right, so we want you to give the public permission to walk along the beach from one park across your property to the park down the beach. Mr. Nolan said, oh, well, if you're going to do that, then that's a regulation and you need to compensate me for the, public's use of my beach. You can't just put that as a condition to my permit. And the Supreme Court agreed. They said this kind of exaction has to show what they called an essential nexus, which is essentially a close tie of the condition to a legitimate state interest. And in this case, the court said California had not shown that its condition was tied to a legitimate state interest. In fact, California's justification during the course of the case proceedings was they required these public access easements so that people traveling along the road behind the bungalows could view the beach. And the court said, that doesn't make any sense. How does, providing a lateral access help the view from the road?
You couldn't see.
So,
you can see here, you can't even look up and see.
So they,
the roadway.
so they said, no, this is, in fact, said this was a violation of the Fifth Amendment. And they also said, which was quite a change in the law, was that, remember when I said when there's a legislative action on the part of the regulator, the state, the courts usually give the burden of proof to the challenger. And, the challenger has to come in and explain why and, make its case. In this case, the Supreme Court said, it's up to the agency, the permit agency here, to justify its rational nexus. And in this case said that they didn't do that. So this case, the Nolan case, is considered one of two cases that established the dual rational nexus test. So this is the first test, the essential nexus, and this next case we're going to talk about is Dolan versus the city of Tigard, a second exactions case where the court established the second test. So in this case, coming out of Oregon, a commercial establishment wanted to expand its building, and the court said, you can do that, we'll issue you a permit to do that, but because of your location, we're going to require certain conditions to the permit. And one condition was the landowner had to give an easement for a bike path that had been planned and that traversed the property, and also for a storm drainage area that was part of the property, and had to give an easement to allow those path and storm drainage improvements. And the result of this regulation in this circumstance was about 20% of the property was not to be built on because it was going to be subject to the easements. So the property owner said, well, this is a takings. If you're going to require me as a condition of the permits to do this, then you should pay me just compensation. And the court said, yes, that's true. And in this exactions case, the court found that the conditions had an essential nexus to the legitimate public purpose. Providing an easement helped for creating the bike path and for protecting the drainage area. But it said, we're going to require something else. The second test in these exactions cases is that the exaction has to be roughly proportionate to the impacts. So, and that language you might recognize as being part of Florida impact fee law. In other words, though it might be a legitimate purpose and an essential nexus was shown in that the first instance, there was no evidence in the record here that the amount of property that was being required as a condition was proportionate to the impact of the expansion of that property. So in this case, the court found that this was unreasonable and a takings.
So that means the dual nexus, that's two parts. You have to have a connection to the impact, central nexus, then you have to be roughly proportional. The exaction has to be roughly proportional to the impact created. So you can't require a single-family house to build 5 miles of 4-lane divided highway for transportation purposes.
But you can require it to contribute to a fund at some later future
Maybe,
date.
right, maybe an impact fee or some kind of fund proportional to their impact.
But it has to be proportional. It has to meet, even if it's giving money, and that's what this next case is about. You have to meet the dual nexus test. And so the recent case that really sort of hammers this home is the case out of Florida, the Coons versus St. Johns River water management case. These are interesting facts. And that raises a question about just how well it fits into the takings genre, but it's important for a number of principles. In this case, there was a property owner that wanted to build on property that had significant wetlands and came to the water management district for a water management district permit and talked to the staff about it, went through the process of, applying and getting comments back and meeting with the staff and negotiating what the conditions might be. And the staff said, well, there's a couple ways that you can mitigate, your wetlands impacts, and here are 3 different ways to do it. You can pay into a fund, you can give us an easement, you can make some improvements off-site, within the same basin, and all of that, will get you a recommendation from the staff for a permit. Kuhn said, no, I don't want to do any of those things. I'm just, I just want to go to the district and take my chances. And the district said, why don't you want to do any of those things? They denied the permit, and the property owner, Mr. Kuntz, came to the court and said, this is a taking. It was an attempted extortion on the part of the staff, and I should get compensation. So this case eventually got up to the Supreme Court. It was actually Mr. Kuntz Jr. who was around when the court decided. Mr. Kuntz was elderly and didn't survive, but the Supreme Court decided that the dual nexus test applied in this case, even when the permit was denied. And so we weren't focused on the conditions of a permit, because there were no conditions of a permit. There was no permit. It was the action of the staff in trying to mitigate and suggest these conditions that was unconstitutional. This is what makes it a crazy case, because the court didn't actually rely on takings law here, although it's considered sort of part of that set of takings cases. They said this was an unconstitutional conditions case, that government may not require an individual to give up a constitutional right, in other words, it's just compensation for taking, in order to obtain a government benefit. And the court also said that the dual nexus test applies to money, not just land dedications. But they also, in a very squirrely way, said, even if there was a unconstitutional condition violation here, we're not saying that there's a damage remedy. In takings, there's a damage remedy. So they said only if the state law requires it. So this is a case I really kind of doubt that you would see on a test, because it is a bit squirrely, but it does, for at least one point, and make a difference to the takings cases, and that is for exactions, money conditions can be considered
APA
a
spent a lot
violation.
of time trying to deal with this particular case. And we expect it may show up on the exam, but we have not seen it definitely on the exam yet.
The Florida people should know this case because it's one of those, crazy Florida cases, but it's also important for that issue regarding exactions applying to money conditions.
Don't have it shown up on the question.
So we'll go on because we spent enough time on this. Okay, so we're done with the takings cases for the time being, and let's go on to due process. Again, this is the Constitution, federal Constitution protects persons from deprivation of life, liberty, or property without due process of law. And that's applicable to state action through the 14th Amendment. And there are two types of due process cases. Persons are entitled to procedural due process. In other words, persons are entitled to a fair procedure when their rights are involved. The court will determine in this instance whether for procedural due process, there's been reasonable notice and an opportunity to be heard by an impartial judge, tribunal. That's the basics of procedural due process under the federal Constitution. And that process cannot be arbitrary or capricious or confiscatory. The other kind of due process is substantive due process, and this is where the court looks at the substance of the law, the content of the law, not how it's being applied through the notice and hearing process, but what does the law actually say? And in this case, in substantive due process, the plaintiff will say that the content of the law is arbitrary and capricious. It has no reasonable basis. And a lot of zoning cases, a lot of regulatory cases are, in the past anyway, has been challenged on their reasonableness. It's just, if it's not a taking, but it goes too far, it's unfair, it'll be brought under the due process clause. And the courts give a low level of scrutiny to due process claims, federal courts in particular. As long as there is a rational basis for regulation, the courts will uphold the regulation, and they give the government the benefit of the doubt. Again, it's up to the plaintiff, the challenger, to prove that there's no rational basis to the regulation in order to find a violation. For certain kinds of cases, the courts will do more than a low level of scrutiny. They will look a little bit more closely at the regulation, and they won't ask whether there's a rational basis, but rather, does the regulation substantially advance a legitimate state interest? And in certain cases, the court will even look at a law in terms of strict scrutiny. And strict scrutiny usually involves First Amendment rights or a very limited set of particular kinds of rights, abortion, right to die, things that are very personal kinds of liberty issues. In a due process case, there's no need to prove a loss of value. The remedy is not money damages, but nullification of the law. So let's look at a couple of kinds of due process cases that arise in the zoning context. And the first case to look at here is City of Eastlake versus Four City Enterprises. In this case, in the city charter required zoning changes to be subject to popular vote and to be passed by popular vote by 55%. And the city had rezoned property from industrial and to, from industrial to multifamily to build, so the developer could build a high rise, but it went to referendum and the voters did not approve that by 55%. They overturned the city's approval. Developer went to court and said, this referendum requirement is unfair. It's a violation of due process, arbitrary and capricious. It needs to be overturned on a constitutional basis. And when it got to the Supreme Court upheld the referendum power here and said, this is a legislative act. Under our review of legislative acts, we're just going to see whether it has a rational basis. The state constitution here specifically reserves the right of referendum to the people as a legislative act, and so plaintiff went home without a win. Now, one question is whether in some states where zoning is not considered legislative, but a quasi-judicial act, the court would look at the referendum power the same way, the referendum for zoning in the same way. We don't know. All right, so will the court examine motives for legislative enactment or executive decisions? Well, not generally, especially legislative decisions. Although legislatives and executives need to not discriminate and treat like people alike, generally, if it's a legislative action, you only need to have a rational basis for your legislative action, again, the lowest level of scrutiny. However, and zoning, let me just back up. Zoning, by its nature, discriminates, right? Some properties are zoned for higher density intensity than other properties. But the courts say for zoning purposes, that's a legislative action that we're not going to look very closely at as long as there's a rational basis. And zoning's been accepted as being a legitimate exercise of state police power to protect the community and for other reasons, for aesthetic reasons and so forth, so that it won't be overturned. On the other hand, there are some exceptions where there is a regulation that affects fundamental rights or a protected classes being distinctions based on race, religion, or national origin. Then the court, in reviewing a regulation that discriminates and affects these fundamental rights or protected class, will apply the highest level of scrutiny. And they'll say, if you're discriminating for between racial minorities and the majority, then the government has to show a compelling state interest for its regulation. And whenever you see compelling state interest identified by the court, you know that the government's going to lose, because it's very rare that the court will find a compelling state interest to discriminate. There's also a level of intermediate scrutiny that the court will sometimes apply to certain other classes or groups that are not considered protected classes, but classes that are sort of semi-protected. And those are, for example, classes that are persons that are handicapped or sexual minorities. So there's that intermediate level of scrutiny there. Rarely applies in zoning, but it's important to know the distinctions.
A higher level of scrutiny apply to a protected class as opposed to a semi-protected class.
Okay.
And the higher scrutiny means that it's going to be more difficult for the local government or the state to prove their case. The court's going to look at it much harsher or much more detailed. That's I'm a layman saying that, not an attorney. I don't know. Want to say it in a different way?
Oh, so the plaintiff would be the citizen being discriminated against?
Right. Right.
Oh, okay, okay,
Right.
okay. I wasn't clear on that.
Right.
No, it's clear.
But the federal government allows discrimination for housing persons.
Well, we'll get into some of these cases. So, for example, Village of Arlington Heights was a case where a church wanted to build subsidized multifamily low-income housing in a suburb of Chicago, which was largely white, did not want a low-income housing project, and refused to rezone the property to allow the low-income housing project. This is not an unusual example, right, throughout the country. The church sued and said this refusal to rezone has a negative impact on a protected class, that is racial minorities. Then the court should look with strict scrutiny on this and strike down the government action. And the court said, well, in order to prove a negative racial impact, this discrimination, you can't just look at the impacts. You have to have proof of discriminatory intent. The government has to clearly be doing this, intending to discriminate. So, you know, city council members who are saying, we do not want those kind of people here, might show some sort of intent. But otherwise, it's going to be very difficult to overturn a rezoning based on impacts on racial minorities for constitutional purposes. But as you pointed out, fair housing laws can protect those racial minorities without proof of impact. So if you're going to challenge this kind of rezoning, you can challenge it without having to prove discriminatory intent, and only prove discriminatory impact through the fair housing law. Another case bringing in this question of whether there were protected persons that deserved more scrutiny by the court was Village of Belterre versus Boras, which involved a town on Long Island, which was adjacent to the State University of New York, and it had a lot of students around. And the town, the village, did not want to allow a lot of student housing. And so to do that, they created a zoning ordinance that allowed for single family zoning, but they defined zoning to exclude student housing, basically by saying that a family does not include more than 2 unrelated persons living together. And that was challenged and eventually went to the Supreme Court, and the Supreme Court refused to look at this with more scrutiny than the typical fairly debatable low level, is there a rational basis for this? And so the village's ordinance was upheld. How about the Equal Protection Clause, which protects against discrimination when there is a minority of disabled persons, or in the case of City of Claiborne, 1985, these persons were described as feeble-minded and retarded, and the city denied a special permit for a group home for these disabled persons. And because of that denial, the group home challenged the regulation and asked the court to find that, in their words, retardation was a quasi-suspect category that required more scrutiny, heightened scrutiny, under the Equal Protection Clause. The court refused to give that kind of heightened scrutiny to disabled persons. They distinguished this group of disabled persons from the heightened scrutiny that they give to race, religion, national origin. So they refused to give that heightened scrutiny, but they nevertheless overturned the regulation on the rational basis ground, saying there wasn't a rational basis. So sometimes you lose on the principle, but then you win on the on what you weren't expecting to win on. Again, federal statutes can protect what the Constitution does not protect. So in this instance, the Americans with Disabilities Act, protects what the Constitution might not protect. And the federal statute, which is known as Section 1983, is a statute that protects federal rights and is used quite often when challenging regulations, because remember, for example, in a due process challenge, your remedy is not to get compensation if you're successful, but it's to overturn the regulation. Section 1983 allows persons whose due process rights or equal protection rights were violated to get compensation. So it's an extra protection for those rights that otherwise Constitution just says the regulation's unreasonable, you have to invalidate the regulation. Okay, let's go on. Again, the Fair Housing Act is another one of those statutes that protects more than the Constitution protects. And one instance in which it was brought into play was the City of Edmonds versus Oxford House case, in which the City of Edmonds, which is outside of Seattle, regulated in its zoning basically to disallow for group homes because it defined family as no more than 5 unrelated persons. The Oxford House is a really well-established nonprofit that runs group homes for recovering alcoholics, and they wanted to locate an Oxford House there, but they were basically told that their zoning didn't allow it, and they were cited for a code violation. Oxford House here claimed that the Fair Housing Act prohibited discrimination based on handicap, and the Supreme Court found that yes, this ordinance should be and could be reviewed under the Fair Housing Act. But even under that review, the court found that it was reasonable under the act because the intent was to preserve the family character of a neighborhood. So Oxford House lost in this instance. So we're gonna move on to. Are you tired yet? You have some more cases, but you'll have a chance. Let me pause here and say, this is where the resource materials are so good. You know, you can go back, you can get summaries of all of these cases. Read the cases. Some of them are, you know, are easy reads.
The Law Division of APA has put out a summary of most of these cases, and I will have that on the FTP site for you, as well as this presentation.
Yeah, so
The Chapters President Guide has some of them, but the APA went, the division put together specifically to sort of address the exam, many of the cases here.
and we've gone into some detail on these cases because this, you know, the facts are important. I think they also may help. They're all stories, you know, and they help you if you know the facts and the stories. They help you get to the principles that are being decided. And
sometimes on the exam, they will not ask about a specific case, but they'll ask about the principles. They'll have a scenario question that forces you to know what dual nexus is because it asks you how do you do this, and it's dual nexus is what your test is that you have to use. So it's, you know, it's a lot of scenario questions utilize some of this information.
yeah, so it's important to know the stories behind the cases and, you know, identify the case names with the principles. Let's see, we're going to pivot now to some state law cases. We're now out of the federal constitution and statutes for a while. And let's look at some cases from the states that are likely to come up on the exam. And one important series of cases, the Mount Laurel cases, come out of the state of New Jersey, which, like many states in the 60s, were experiencing loss of basically more wealthy or middle class white populations to the suburbs, known as white flight, and leaving the cities in bad economic shape. That's turning around now, but back in the 60s and 70s, this was a very important population trend. And as a result, many of the suburbs of these cities zoned to discourage integration and, you know, the movement of the racial minorities and economic minorities to the suburbs. And in this case, the first Mount Laurel case, Mount Laurel had a PUD zoning that the African American community wanted. It claimed to be discriminatory. That the AME Church had asked for permission to rezone PUD to allow for townhouses or replacement housing, and the township denied the rezoning. The New Jersey Supreme Court took this case and interpreted the state constitution to require all municipalities in New Jersey to provide their fair share of the regional need for affordable housing. The Supreme Court did not look, the US Supreme Court did not look at this case. So this is a case, a state law case from the New Jersey Supreme Court. This created a huge series of cases to follow. The New Jersey towns were very reluctant to provide their fair share of regional housing. And when the next case came up to the Supreme Court said, we meant it, and you have to provide a fair share, and in fact, the state needs to do it as a whole, not just this particular municipality. And so the state legislature got on the ball and adopted legislation to apply statewide to create this fair share program. And they created the standards so that the New Jersey Supreme Court would not create the standards for the state.
We haven't covered history yet, but another thing to note in these two cases is that Paul Davidoff, who was the father of advocacy planning, was involved in both of these through, I think it's called something like the Suburban Land Institute. And we'll talk about that more when we do history. And that connection
Next
comes
slide.
up, that's why it is.
Yeah, okay. You can go to the next slide.
Yeah.
Okay.
When I flip the other window open, it won't let me do that until I.
Okay, sorry. There's actually another Mount Laurel case too. I mean, the cases have been generated over more than a decade trying to figure out how to make the fair share requirement work, because it is, according to the New Jersey Supreme Court, a constitutional requirement. So moving on back to the federal law and the First Amendment, where we look at some free speech cases. Okay. And how many? I think we might need to go. Yeah, no, there's some more.
53 and 36.
Okay. The last part is a lot easier. That's not as much. Not as much case. Okay. So the First Amendment protects free speech. And the court has held that sexual expression is a form of free speech. So there are a number of cases involving zoning regulations that try to regulate the location of adult-oriented uses. And one of the important ones to know is Young versus American mini theaters, where Detroit adopted a zoning system that dispersed adult entertainment, required, spacing between adult uses to. Sorry.
1,000-foot rule.
Yeah, something like that. Yeah, that's a typical kind of spacing requirement. And this is in order to prevent concentration on a skid row kind of thing. Yeah. And the question was, what kind of scrutiny will the Supreme Court give to this zoning regulation that implicates free speech? Will they do strict scrutiny and require a compelling state interest so that zoning cannot really regulate this? Well, Supreme Court decided that this kind of speech is low-level speech, even though it is protected speech. And so they were not going to strictly scrutinize this zoning regulation, and declared that the city's policy goals can be considered. It's okay to use zoning to control sexually explicit theaters and bookstores through this kind of separation requirement.
Does this fall under the commercial speech versus individual expression?
No, this is a specific kind of sexual expression speech. Yeah. The kind of twin to that case is City of Renton, where in 1986, the Seattle suburb required this separation from other kinds of uses. And the theater, an adult theater owner, sued to say this was a violation of free speech. And the Supreme Court again said, no, free speech, this kind of speech is low level, low value speech, and only intermediate scrutiny applied. They were not going to apply strict scrutiny. As if there's a substantial government interest, restriction is really a restriction on time, place, and manner, and not content. And there is a reasonable alternative avenue of total communication. In other words, no total ban, then these kinds of regulations can be upheld. And so it's important for a number of reasons. You may have been involved in adult use regulations in Florida, where I've done several of these, where the number one thing you want to ensure is that there is at least one place where these uses can locate, because you cannot have a total ban on the uses. So as long as there is some place, it's okay.
In practice, can a municipality create a zone for such uses?
Absolutely.
Okay,
Yes.
but thereby prohibiting it outside of that zone?
As long as it's within the city, in that zone, there's no total ban. Right. So free speech also applies to signs and billboards. And this is another important case to know, Metro Media versus City of San Diego, where the city banned off-premise outdoor advertising display signs. In other words, billboards, off-site billboards, and justified that as a means to improve the city's appearance, prevent dangerous distractions to motorists. They allowed on-site billboards that relate, to the property on which the billboard is sited, but off-site billboards were prohibited. The lower court ruled that this hindered First Amendment rights, subject it to strict scrutiny, and said the city can't do this. But the Supreme Court did not find this to be unconstitutional. So even though there was a distinction made allowing on-site billboards versus off-site billboards, the court said, let me back up here, because I'm getting ahead of myself. In this case, because the regulation allowed on-site commercial advertising but did not allow non-commercial speech, the court said that this gave a greater degree of protection to commercial than non-commercial speech and went too far. The court is very concerned about protecting non-commercial speech. In other words, a property owner who wants to put up a sign saying, "End the war," whether it's a billboard or any other sign, is usually protected by the Supreme Court for those non-commercial speech rights. Or political sign, vote, in favor of such and such.
The court's ruling on motorist discretion elements of it?
Yes, the courts will allow off-site billboard restrictions if you take care of this commercial versus non-commercial issue. They will allow a prohibition against billboards, off-site billboards, based on safety issue.
Sign stuff is really.
Sounds very complicated.
Conference typically just deal with signs sometimes, because it's very complicated.
Great.
The Federal Highway,
Communication Act.
it must have specs on these things.
Yes.
There must be.
The other thing is the billboard agency has been really strong in terms of prohibiting certain types of restrictions.
Right.
Too. So
So under the Federal Highway and state laws on, that that are based on the Federal Highway Act. You can prohibit off-site advertising billboards in a certain area along highways. But you cannot require existing billboards to be taken down unless you provide just compensation. It's a complicated issue.
Speaking of which, oh boy.
Okay, so here's another complication. Reed versus Town of Gilbert, which is a very recent case. This is a case that the Supreme Court reviewed a sign regulation that made distinctions between certain kinds of temporary signs. And for different kinds of temporary signs had different sizes allowed and time frames under which the signs could be posted, and numbers of signs that could be posted. And the court found that that was a violation of the First Amendment, that signs that are based on content have to be strictly scrutinized. There has to be can you go to the next? I think this is the test for the next. No, I guess not. Maybe in other materials. That you can't, if signs are content based, then the government has to provide a compelling state interest for that that discrimination. And again, if you see compelling state interest and strict scrutiny in a First Amendment case, you know that the regulation is going to fail, because it's very rare that the court will accept a justification under that circumstance. So content-based signs are unconstitutional, violation of free speech. You can regulate time, manner, location, size. You can't regulate on the basis of content. And frankly, it's very hard to do sign regulations that don't somehow identify the content on the sign before it says how you can regulate the sign. So it's become very complicated to do sign regulations. Real estate signs are temporary signs. This was also included, in the case. Treated differently than political signs, treated differently than event signs. The court said all of that, you can't treat all those things differently. They're all content-based. They can only be regulated time, place, and manner regulations.
Great things for federal statute. So this is what the rules are.
This is a constitutional issue. Yeah, this is.
That was just two items that means usually not. It's usually full scrutiny and
compelling state interest.
Means that
the regulation's going to fail. Okay. It's rare that a government can justify a regulation when that kind of scrutiny is involved.
We have 15 minutes.
Okay. The First Amendment also protects against discrimination based on religion and prohibition. That's you cannot prohibit free exercise of religion. And the First Amendment also says that the government cannot establish a religion. So there are a couple of cases involved in that religious exercise issue. Larkin versus Grendel's Den was a case in which a Massachusetts statute gave schools and churches power to veto the issuance of an alcohol permit for establishments within 500 feet. And an establishment was prevented from obtaining a liquor license, and the Supreme Court found that this zoning regulation violated the Establishment Clause by essentially delegating police power to schools and churches. So that's a good case that will probably end up. It sometimes ends up on the test. In terms of free exercise, I don't think that Jehovah's Witness case. There's an important case called Lemon versus Kurtzman. Look for this one, where the court says that a regulation that potentially interferes with the free exercise of religion will be subject to a three-part test. They'll look to whether the government regulation has a secular purpose, that it's neutral, it doesn't advance nor inhibit the exercise of religion, and there's no excessive government entanglement. And one example of where a regulation was struck down was a Florida case out of city of Hialeah, which banned ritual animal slaughter, which is really central to the Santeria religion, but made exceptions for kosher slaughter. And the Supreme Court found that this was not a neutral law of general applicability, but it had targeted a particular religion, and therefore was a violation of the First Amendment.
Why didn't the environmental example violate the Establishment Clause like it did in the alcohol case?
The Larkin case, it did violate the Establishment Clause.
Oh, it did also?
Yeah. Larkin did violate the Establishment
Okay, I
Clause.
don't know about any case. This was the adult.
We've talked about two cases. So Lemon v. Kurtzman is just the principle, okay?
I'm saying the prior case where there was just somewhere in the township,
The city of Renton.
but why wasn't that case also?
Well, because here he's allowing the church to make the decision. The other situation, the city made the decision.
But even here, it says mass statute, it's allowing the state making the decision, it's not. Oh, gives schools and, okay.
Yeah.
In fact, seems exactly the same, so it just seems, okay.
I'm going to move this on.
Okay.
You want to?
It's important to know the RLUIPA statute, religious land use.
In red in this presentation particularly are really key because they come up all the time.
The Religious Land Use and Institutionalized Persons Act is an example of where the federal statute provides more protection than the Constitution, okay? Also known as RLUIPA, which was passed to protect against discrimination on the basis of religion, but it is directed to land use regulations and regulations for institutionalized persons. So this statute requires that land use regulations may not impose a substantial burden on religious assemblies and must use the least restrictive means and have a compelling government interest for any such restriction on religious assemblies. That's one thing, the substantial burden requirement or prohibition. And then secondly, the land use regulations cannot treat religious assemblies unequally from other types of assemblies. Okay, so a couple of cases that have come up in terms of substantial burden include this Club versus City of Chicago case where a conditional use permitting process was challenged as placing a substantial burden on a religious, on the location of churches. And basically, the court said that the conditional use process, even though it might be more expensive for applicants to go through, this was not a substantial burden on the exercise of religion, but was rather a neutral law of general applicability with a rational basis. Okay, so substantial burden is fairly hard to prove under RLUIPA. There are other cases where the assembly issue has been more successful for religious groups challenging under RLUIPA. For example, in Surfside, there was a case under which churches were not allowed to locate in a zoning area where other kinds of assemblies could locate. And this was found to be a violation of the RLUIPA. Okay, and we're just gonna zip through this. Zoning growth management cases. You see this in another, I think in another lecture, but this is just a typology of kinds of zoning regulations, early regulations regulating how much, where, and what can locate. In the 70s, some more emphasis on when uses can locate. That's when concurrency and adequate public facilities regulations came in, and the present time being additionally concerned with the quality of architecture and design. Okay, here's another case that falls into the category of early zoning regulations sort of based on nuisance law and upholding those zoning regulations. In this instance, it was a statute in Kansas during early prohibition times, basically, that declared liquor sales a public nuisance and regulated against the location of a brewery. The court found that this regulation was okay. It was not a taking or due process violation because the state had has police power to protect against public nuisances, in which case a brewery was considered a public nuisance. Village of Euclid, if you don't know this case, just don't even bother to take the test. This is the case that upheld the standard zoning kind of regulation that establishes different zoning districts for different uses. In this case, the village zoned property that was, as a result of the zoning, reduced by 75% in value, and the owner claimed a taking, a due process violation, an equal protection violation, and the court held that zoning here was a legislative enactment that was upheld under the principle that if it's a legislative enactment that is fairly debatable, that shows that it's not arbitrary and capricious, then it is not a due process violation. So this is the grandfather case that upheld the original zoning based on the Zoning Enabling Act.
We'll get into many of these subjects. I just want to touch on these, and then I think we're going to have to end on these two.
Okay. Well, some of the growth management cases, there are 3 of them to know. One is the Ramapo case, which adopted what essentially is what we know as concurrency. a plan and zoning regulation based on the adequacy of public facilities, and permits were issued based on, points for making those public facilities available. And the New York Court of Appeals upheld this system. And it was the first case that really upheld the power of the town to plan for its future, and a national model was really built, of concurrency was built on this case. Very important case. The Petaluma case was a case involving a growth management boundary and a phased permit system where building permits were limited to a certain number per year. The construction industry sued in federal court, said that this was a violation of the constitutional right to travel without a legitimate government interest, and a violation of due process. And the federal court upheld the city of Petaluma's system, growth management system here.
In Petaluma and Livermore, you need to know the difference because that comes up all the time.
Right. And okay, so Petaluma was a federal case. Livermore came out of the state of California, and this was an ordinance that had limited residential building permits until the adequate public facilities were provided. This was a challenge from the home builders, arguing that this interfered with non-resident right to migrate, in other words, right to travel. And the state court here upheld the system.
The infrastructure had to be in place before permits.
Correct.
And with that, we've run out of time.
So good luck, everybody. Study hard.
Okay, I'm going to hook up the my other mic here, and then we'll go on a little bit. I'm going to look at some. I know there's some people that raised some questions here. I know that there's people that raised some questions here, so let me take a look at some of the questions. Maybe everybody's got. All right, so I had, so the ability is general purpose local government is based on whether a state operates under home rule or Dillon's rule, correct? Well, not exactly. What the powers of local governments are based upon whether it's a home rule or a Dillon's rule state. In a Dillon's rule state, a local government can't do anything unless it has explicit legislation from the legislature allowing it to do certain things. That meant prior to 1968 in Florida, cities had to go all the time to the legislature to get the power to buy that land or to pass this regulation, whatever. So in the home rule state, basically local governments can do anything except where they're preempted by either federal or state legislation. Bo, I think you tried to ask a question of Nancy, but unfortunately Nancy was taped. I used the law presentation you just had was from the spring, and I thought it was better to use Nancy than me to do it. So in the Kilo case, in the Kilo case, I think you're talking about, yeah, the proposed economic development never happened. So they took Mrs. Kilo's house, and actually she got picked up by a group in California and moved to another location so that they can have it as a landmark to bad governmental action. And the development that was supposed to be, I think, either biotech related or something like that never happened. Okay. I think that's the questions we had here. Let me go to some other things. I'm going to give you this handout on the Constitution, which covers the constitutional amendments that we need to know. It's not moving down, but there it goes. So it's the 1st, the 5th, the 10th, and the 14th. So you have it. I'm going to attach here also the APA law cases. That this doesn't cover every case we need to know. For instance, some of these earlier ones, like the Mugler versus Kansas and the Munn case and things, aren't in this set, but it does have nice, for the cases that are addressed here, it does have a nice write-up of what the case is, what the facts were, the discussion, what the holdings were, and what the significance is from APA's point of view. Okay. And now I lost my, just a second, I'll get back here. And okay, so the last thing we've got about 10 minutes for is to do some practice questions. Anybody have any questions before I get to the practice questions? Can anybody hear me? Yes, can anybody hear me?
Yes, we can hear you.
I can hear you.
Unmute yourself and let me know. Or maybe you all got muted again somehow. No, it's only some of you. Somebody unmute yourself and let me know you're hearing me.
I can hear you.
Yes, we can hear you.
Or hearing me, correct?
Yes.
Oh, wait a minute. The problem is, okay, try again. Can people hear me now?
I can hear you.
Okay.
Okay.
We can hear you.
My speakers were on the wrong set of speakers. All right, got that, guys. All right, I'm going to do some law practice questions, and then we'll end the night. This one's easy, and it has the answer showing. So, which case first established the concept of public welfare? And as Nancy said, that's the most important case you need to definitely know. Euclid versus Hamler. By the way, I want to reiterate on Nancy's presentation, which I've made a few little typo corrections on the version I will give you for the slides. The important cases are in red letter title. Okay, so the other cases are there to know a little bit of the principles, but the cases that tend to come up on the exam are all in red. And one of those, of course, is Euclid versus Ambler, which basically has upheld the zoning regulations as a legitimate exercise of police power asserted for public welfare. So the court's decision established local zoning as a legally defensible land use and formed the basis for court decisions for several years. All right. Since a number of people mentioned Mugler versus Kansas, I put one of the questions here for that. So Mugler versus Kansas Supreme Court case, anybody can answer. What did it do?
A, police power.
Yep, upheld the use of police power. All right. It decision held that a state's legislation prohibiting manufacturing intoxicating liquor within its jurisdiction did not infringe on any right or privileges secured by the Constitution, including the 14th Amendment, was not a taking, and found that the authority for the statute strictly relied on Kansas police power. All right. I'll give you some sources there. All right. This one, we conclude, therefore, that under Belterra and the Los Alamos Hills, the concept of public welfare is sufficiently broad to uphold Blank's desire to preserve its small town character, its open space and low density of population, and to grow at a orderly and deliberate pace is a finding from which famous law case?
Rampa persons.
So I heard Ramapo, which is all about adequate public facilities.
Or Petaluma.
Petaluma, city of Petaluma.
So I heard Petaluma, and let me get down there. Correct answer is Petaluma. Alarmed by the accelerated rate of growth in 70-71, the demand for even more housing and the sprawl of the city eastward, the city adopted temporary freeze on development in early 1971 to correct the imbalance between single-family and multifamily, curb the sprawl on the east, and retard the accelerating growth. The council in 72 adopted several resolutions, which are collectively known as the Petaluma Plan. The plan, on its face, limited to 5-year period, fixes a housing development growth rate not to exceed 500 units per year. The controversial 500 unit limitation on residential development units was adopted by the city in order to protect its small town character and surrounding open space. Construction Industry Association filed suit in federal court saying it was arbitrary, in violation of the right to travel, unreasonable burden on interstate commerce. The final decision came from District Court of Appeals, which said it did not unconstitutionally restrict the right to travel, and the concept of public welfare is sufficiently broad to uphold Petaluma's desire to preserve its small town character, its open spaces and low density of population, and to grow at an orderly and deliberate pace. The regulation is rationally related to the social and environmental character of the community and does not discriminate against interstate commerce or operate to disrupt its required uniformity, and that the appellants claim that the plan unreasonably burdens commerce must fail. The reason why I included some of this is that they have been known on the exam, and you'll see this in the test taker comments, to quote pieces of different cases. Sometimes that's as simple as Pennsylvania coal, when it talks about when a regulation goes too far, you know, et cetera, et cetera. Or other times they do something like here for Petaluma, for Livermore. You definitely need to know the difference between Livermore and Petaluma. That does tend to come up in the exam. You may only get 2, 3, 4 law cases directly, but the realm of what you need to know is probably 12 to 18 court cases. And we've tried to go over the main ones in this presentation here. So you need to know more than what you're going to get tested on, but that's the way the exam works overall. You need to know a lot more stuff because you never know what's going to come up. And unfortunately, we don't have any easy way for you to get around that because the test is changing from, you know, there's 2 to 3 versions at any one cycle, and they'll change. That there's, for instance, you got 150 questions that you're being tested on. There's a pot of questions, we've been told, that's at least about 850 questions. So what is that? About 5 different versions or something like that, 6 different versions they can have, even if they had them exclusive. So there's a myriad of different combinations of questions they can use on the exam. All right. And this will probably be the last question, but I'll give you this set of questions on the FTP site. Which of the following statements best summarizes the concept embodied in Dillon's rule? Anybody?
A. Local governments are devoid power from the state.
Right. They're devoid of authority, absent an express delegation of power from the state. So in 1872, Judge Dillon ruled that local governments were treated as subordinate instruments to the state and were authorized to perform only those functions permitted by state legislation. Now that's as opposed to home rule states where typically by legislation or in the state constitution, municipalities are embodied to do anything that's not expressly prohibited or preempted by state or federal legislation. An example of a preemption at the federal level is on the Telecommunications Act, which we'll talk about another time, which basically says that local governments cannot regulate cell phone towers based on their medical impacts from electromagnetic radiation, okay, among other things. That's a preemption. Another one at the, say, Florida level that I dealt with all the time as the Water Management District is that the water management districts in Florida were given the exclusive authority to regulate the withdrawal and transport of water. So when one county who is putting well fields in another county, and the county tried to prohibit that withdrawal and transport outside its boundaries, that violated that state preemption. Okay. More recently, They've done things like preempt local governments from regulating gun ranges in backyards. That's totally a state issue. So those are preemptions, even though we're a home rule state. Hopefully this was helpful. If you've got more questions, go ahead and feel free to send it to me. Tomorrow, I will put all of this on the FTP site and send out an email giving you the instructions for that. And if you still have questions or you don't get the email, send me a notice. Okay. Hopefully was this useful this way? I realize it wasn't as open to active questions directly as the normal sessions. We're only going to do this 1 or 2 more times, like I mentioned at the beginning. We may do it for historic preservation, and we may do it for transportation. And why I do it for those and this one is because I think there's special expertise that really helps on a couple of these issues. And the rest, yes.
Are the previous presentations from the previous last 2 classes also on the FTP?
Yes.
Okay, they're still there.
Not only are they on the FTP site, but if you go into some of the other folders of past sessions, you can find probably 4 or 5 years of recorded sessions done from our classes.
Okay.
Okay. So there's a lot of stuff on the FTP site. You have to learn to go through the folders, but all of and these will be immediately obvious because they're by date and then by subject. When you first get on the FTP site, it will have the date, so the Thursday date so far, and then it'll say what it is, like history and Enviro, EJ, NEPA, something like that. Or this one will be like planning law, okay? And then starting, I do want to say that not starting this Saturday, but starting the following Saturday, September 5th, we will start the Saturday weekend question sessions. Now, right now, I've got them scheduled to start at 8:30 and go till 1 o'clock. And they will be just focused on planning, on practice questions to try to get into the use of dealing with questions. And we tend to stay on a question until everybody understands why the answer is the answer and why other answers are not the answer. And we try to get in the mindset of APA about how they think about certain aspects. Okay? I know I'm talking real fast.
Well,
Henry, the Saturday classes, those will be recorded as well, correct?
Yes, they will. The one thing though that's a caveat on that is because I can make fair use of question sets even when they're copyrighted. However, I cannot put them on the FTP site in toto. So we will use different questions and they will be recorded on the GoToWebinar, but I cannot take like whole sets from APA or from other sources and put them on the FTP site in text. Does that make sense?
Are we still going to have a class next Thursday then, if that's the case?
Yes. Starting next week, we'll have Thursday classes on topics, and I'm going to come up with a couple of people asked me to come up with a schedule, and since I'm doing all of them myself, we're not depending upon different, juggling everybody's outside schedule. I'm going to come up with a list, and I'll probably do it in the order of the exam topics that are. We're going to do ethics next week. All right.
Good.
And then after that, they will be probably done in the order that's in the outline. So that for the topics that are remaining. Okay. And I will come out with a list like that. But next week will be ethics, and I will be doing it myself. All right. And then, like I said, at some point, the only other recorded ones we'll use are probably transportation and historic preservation. But I have to double check on those topics to make sure there's no new issue that's come up on the exam. I don't think there is, so I don't think I need to revise those 2 presentations. Other things we may need to revise. All right? And as always, if you've got questions, send me an email, okay? All right, with that, I'm going to log us off.
Thank you,
Yeah.
Henry. Good night, everybody.
Sure.
Thank you.
Thank
Bye.
you.
Thank
Thank
you.
you.